Pick it up the screen. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Today, we have an arraignment docket. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are commonly referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as petty offenses. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense that they're charged with. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. We have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to maximum 99 years to life in the state penitentiary and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the case that you have in this court is not a felony case. It's a misdemeanor case. Misdemeanors are divided into 3 categories. And we'll start at the top and work our way on down to the bottom. We have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanor offenses are usually those offenses, well, they start either in the city court or the JP court or the justice court. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. You cannot get jail time, it's a fine only. The fine maximum is usually $500 on down. Now, however, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. That means it's a warrant for the fine, which means you could be arrested, sent to jail, and you'll be required to either pay the fine or sit out the time in jail. And you, when I say sit out the time in jail, you'll be credited at $100 for every day that you spend in jail. So for example, if your fine was $200, you'll spend 2 days in jail. Now, the next highest misdemeanor is a Class B misdemeanor. If you are convicted of a Class B misdemeanor, the range of punishment is from 0 days to a maximum of 180 days in the county jail. Or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Then the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for one of 2 types of probation. Probation basically means you won't serve time in jail, you'll be out in the community. But there are 2 types of probation. One type is called adjudicated probation, and the other type is called unadjudicated probation. Now, the difference between the 2 is as follows. With Adjudicated probation, you will have a conviction on your record as soon as the case is disposed of. Now, if you successfully complete probation, the court can set aside your conviction. When I say the court, the judge, that is, can set aside the conviction. That is, you will not have a conviction. Now, in order for that to happen, there's something that is called judicial clemency, where the judge can set aside your conviction. Now, you have to first complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. If those three things happen, the court can set aside your conviction. And however, if you get a subsequent offense, in essence, if you get an offense later on, then this conviction can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, they could deny giving you a license, or if you have a license, they could suspend or revoke that license. Now, the other type of probation is called unadjudicated probation. With that type of probation, you will not have a conviction on your record. And if you successfully complete the probation, unadjudicated probation, that is, then the case will be dismissed and you may qualify for what is called a non-disclosure. A non-disclosure means that we cannot disclose the fact that you are on deferred adjudication for this offense. In essence, your record is sealed. Now, the public cannot have access. However, the government can have access. So most of our community is public. And so most of the public cannot have access, but the government can have access. For example, law enforcement can have access. City, state, federal government can have access. Now, as a defendant in a criminal case, you have rights, okay? There are some clipboards that was passed out to you. And on the clipboard, it talks about one of the rights that you have. That is, you have a right to have an attorney. Now, the document, the first page on the document, well, it might be the second page on the document, is titled Judge's Explanation of Rights to Defendants Without Attorney. On that document, it states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may waive your right to an attorney, which means you may give up your right to an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire one, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. Now, if you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial affidavit, a financial questionnaire. The financial questionnaire is the document on the clipboard, probably the last document, that's titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page and half of the second page, because the bottom part of the second page is for the court to fill out, and the third page is for the court to fill out. Now, once you fill that document out, then the court will review the document and the court will decide whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. If you want to waive your right to an attorney or give up your right to an attorney, and if you want to represent yourself, then you can speak to the prosecutor about your case. The prosecutor is the gentleman that's sitting at the table right in front of you. That's Attorney Andrew Hubel. He works for the Jefferson County District Attorney's Office. Now, you cannot talk to him unless you first fill out the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. On that document, it basically says that you're aware that you have a right to have an attorney. However, you're waiving your right to have an attorney to represent you. You know about the dangers and disadvantages of self-representation. I'm going to go over that with you actually in the next second. Now, if you want to waive your right to an attorney, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, if you decide to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, that's titled Judge's Explanation of Rights to Defendants Without an Attorney, there are 5 lines. The first line, the statement is, it states that I want to have my case reset, and that's I want to be given another court date so that I can hire my own attorney. If that is your choice, then you'll put your initials on the first line to the left. If you have already hired an attorney to represent you, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. Now, if your choice is to ask or request that a court-appointed attorney be appointed to represent you, then you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left. Now, if you want to waive your right to an attorney, that is, give up your right to have an attorney to represent you, and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant, and you will date it today's date, which is February 6th of 2024. Now, for those individuals who will be desiring to waive their right to an attorney and represent yourself, that second document, Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, I'm going to go over this document with you, and it reads as follows. I have been advised of the nature and danger and disadvantages against me in this charge. My waiver is voluntarily and intelligently made. I have been further advised this 6th day of February of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled Defendant, and you will date it today's date, February 6th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all the evidence. They will listen to the arguments. They will deliberate, and then they will decide to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. And by waiving or giving up your right to have a trial by jury, you will not be having a trial by jury. Your case will come before the court in one of 3 ways. One way it can come before the court is by way of a bench trial. That is, you want a trial, but you do not want a jury trial. You want the judge to be the judge and the jury. We call that a bench trial. The judge will listen to the evidence, listen to the arguments, then the judge will decide to find you either not guilty or guilty of your charge. The other way that your case can come before the judge is by way of an unagreed plea bargain. Now, a plea bargain is an agreement that you reach with the district attorney's office to settle your case. We call that a plea bargain. If you are unable to reach a plea bargain agreement, for example, the state is offering you jail time, you on probation. That's not an agreement, okay? Because you want one thing, they want something else. However, you want your case to come before the judge for the judge to so the judge can decide what your punishment will be. We call that an unagreed plea bargain. And so when it comes before the judge will decide what your punishment will be within the range of punishment. It could either be fine, it could be court costs, it could be fine and court costs, it could be unadjudicated probation, or it could be adjudicated probation. The judge has that full range to decide what your punishment will be. Now, the other way that your case will come before the court is by way of an agreed plea bargain agreement. That is, you and the state have reached a plea bargain agreement, and so it comes before the court. The court can do one or two things. The court can either accept the plea bargain agreement or reject the plea bargain agreement. If the court rejects your plea bargain agreement, then at that point, you can tell the judge or the court, I take my plea back. You can withdraw your plea. You can say, well, judge, since you're not, if you're not filing a plea bargain agreement that we've entered into, I want to take my plea back. You can do that. Now, if the judge does follow the plea bargain, and if within 30 days you decide that you would like to appeal your case is you would like to have a higher court to review the case to see whether or not this court committed an error by convicting you or whether or not you were wrongfully convicted. You do that within 30 days. You have to first get permission from the judge that followed the plea bargain agreement. If the judge gives you permission to appeal your case, then your case will leave this court and go upstairs to the Ninth Court of Appeals. They will review your case. They will decide whether or not you've been wrongfully convicted. Well, they can decide to grant or deny your appeal. And if they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then within 30 days of them denying your appeal, well, you can file what is called a pro se petition for discretionary review to another court. In essence, you can appeal it to a higher court. The court that you will be appealing it to is the Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you are representing yourself. You do not have a lawyer that's representing you. You'll be doing this on your own, pro se. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not the appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you was wrongfully convicted. They can do one or two things. They can grant your pro se petition, simply find you not guilty, or they can send the case back to the Ninth Court of Appeals, or they can send it back to this court and order this court to give you a whole new trial. Now, the other thing is if the Court of, if the Texas Court of Criminal Appeals, if the Texas Court of Criminal Appeals deny your pro se petition, then at that point, your conviction will stand. Okay. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court to testify. They'll sit in that chair over there. We call that the witness stand. And they could either testify for you or they could testify against you. If you have an attorney, the attorney can ask them questions. Or if you represent yourself, you can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses. Waive or give up your right to have witnesses. That simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify in your case. So the state, the district attorney, the government cannot force you to take the witness stand and testify against yourself in your case. Now, you can waive or give up your right against self-incrimination. That simply means that you will be testifying in your case. Now, you also have a right to have discovery. Discovery means you have a right to see the evidence. That is, you have a right to discover or see the evidence that the state has against you. That is, you have a right to see witness statements, police reports, lab reports, your statement. You have a right, if you had a statement that you made, you also have a right to see videos, audio, or listen to audio recordings. You have a right to see any instruments that they may have that they'll be using in your case. That's called discovery. Now, you also have a right to waive or give up your right to have discovery. That simply means that you will not be having, you do not want to have access to the evidence that they have against you. Now, everyone that's here today for arraignment, you're here because you've been arrested. You were arrested, placed in county jail, and you were released on bond. You're either out on a cash bond, which means you paid the full amount of the bond to get out. You were released on a surety bond, which means that you paid a bondsman a percentage of the bonds to get out, or you were released under a personal recognizance or PR bond, which means that you were released under your own personal recognizance, which means you did not have to pay any money to get out of jail. However, you had a promise to appear in court. Now, every day that you spent in jail, that jail time can be credited toward your punishment. So, for example, let's say you in the state let's say you spent 5 days in jail and then you bonded out. Let's say you in the state have reached a plea bargain agreement for you to serve 5 days in jail. Well, that simply means that you will not be required to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if the state is offering that you serve 7 days in jail and you serve 5 days in jail, we take 5 from 7. That means you only have to serve 2 days in jail. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. You will be credited $100 per day. So, for example, if the state is offering you fine and court costs of $500, you spent 5 days in jail, that means you don't have to pay anything because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you would have to pay $200 because we take $500 from the $700, that leaves $200. And now you'll be required to pay the $200 on the day that your case is disposed of. If you are unable to pay it on the day that your case is disposed of, well, the court can put you on a payment plan, which means that you can pay it off in monthly installments. Now, some individuals, even if you put them on a payment plan, will not be able to pay off the fine and court costs because they do not have the income. Well, if that is the case, then the court can convert your fine and court costs to community service. Every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited towards your fine and court costs. So for example, $12.50, you work 8 hours, that's $100. Okay. So if you owe $200, you work 2 days, 2 8-hour days, that will pay off the $200 fine and court costs, okay? By way of performing community service. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you haven't been in trouble before, first time getting into trouble, the district attorney's office has a program that's called pretrial diversion where they will dismiss your case and you can get it wiped off your record. Now, the way this program works is as follows. You have to, it has to be your first time getting in trouble, cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you with filing an application with the district attorney's office. And if you are accepted into the program, they will dismiss your case. And if you complete the program, then you can get this expunged from your record. Expunged means wiped off, deleted, or erased. It's almost like when they go and look for it, it's not there because you got an expunction. Now, if you are a veteran of any one of the branches of the military service or military forces, Jefferson County District Attorney's Office has another program that is called Veterans Court. With that program, you will get into the program, you complete the program, they will dismiss your case. And once they dismiss the case, you can get a non-disclosure. And as I mentioned, a non-disclosure basically means that we cannot disclose to the general public that you received, that you had this case. However, the government can't have access to it, okay? Now, this court has a program. When I say this court, I'm talking about County Court at Law Number 2. There's a program that's called the CSI program, stands for Community Safety Initiative. That is a program that I started in March of 2017 within 100 days of taking office. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so we started this program to address the issue of recidivism so that we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. Now, the way the program works is as follows. We have partnerships with agencies in the community. One of the agencies that we have a partnership with is Spindletop Center. They are a local mental health center. With Spindletop, they have the capacity to treat mental illnesses or mental problems that individuals may have. For example, you do not have to be incompetent, declared incompetent or insane to participate in the program. You could merely suffer from anxiety, depression, or any other host of mental illnesses. And what they will do, they will first have a private interview. Okay, that interview could be here in the jury room, or it could be telephone, or it could be at their facility. It'll be a private interview between you and the folks from Spindletop. Then they can develop what is called an assessment. Okay, they can conduct an assessment or do an assessment, and then they can develop a treatment plan, either outpatient or inpatient, depending on what your mental health needs are. Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. It's a drug and alcohol recovery program. Spindletop has that program, and the local Drug and Alcohol Council has a program that is called OZAR. OSAR stands for outreach, screening, assessment, and referrals. Those programs, what they will do, they will have a private screening, do an assessment, and develop a treatment plan for either outpatient and inpatient, depending on what your needs are regarding the issues that you may have with drugs or alcohol. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of the areas that you choose, then they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school, you'd like to get your GED, well, CICE also has a GED program, a graduate equivalency diploma program. Now, all of these programs that I just mentioned will not cost you anything monetarily. It does not cost any money. Only thing it costs is time. And in this court, I like to say, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe that if we address the problem, then we can produce productive people. And we believe that productive people will not commit crimes. Why? Because they have too much to lose. And so I always say that when you come before County Court at Law Number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. If we make a difference in their lives, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I've just mentioned, just let me know or let our court personnel know, and we could get you the brochures so that you can be able to get in contact with the individuals that you need to get in contact with, so that you can get into these programs. Now, the other benefit about this program, not only is it free, but all of these programs that I just mentioned can be used as community service. So for example, let's say you are ordered to pay a fine, but you do not have a job, or you can't pay the fine. It's been converted to community service. Let's say if you're in the Spindletop program, for every hour that you're in that program, you're having counseling. $12.50 is being paid for your community, for your fine and court costs, and 1 hour is going toward your community service. Or let's say you're in the GED program. While you learning how to get your high school equivalency diploma, every 1 hour, $12.50 is going toward paying your fine and court costs, and 1 hour is going toward community service. So I tell people this all the time: it's like killing 3 birds with 1 stone. You're in the program, you're doing the community service, and you're paying the fine and court costs, all by doing one thing. Okay. So if you're interested in those programs, just let us know. But at this time, what we're going to do, we have some folks from Spindletop who's going to come and tell you a little bit about the program that Spindletop has to offer. We have Gabby and Deputy Hinton. Gabby, Deputy Hinton, the floor is yours.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's office. I'm here with my co-worker Gabby. Now, Gabby's a qualified mental health professional with Spindletop. The reason we are both here this morning in this courtroom is because the judge cares about every single person who comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation.
And part of this is we understand that being in the court, it's an add-on to your life. We understand that you have maintenance, that's all, you have work, you have jobs, you have bills to pay. We know that this is just an added on pressure for you. And this is why we come to help also. Things like common things like anxiety or the chronic sadness, depression, stuff like that, we understand that. And we are here to either provide support if that's all you need, but we also have a whole host of resources that we can help you with. Or if you'd like to talk to one of us today also, you can and see if we can get your services.
Maybe this is your first time to be here, maybe it's your 10th time to be here, there's still hope. In fact, what we're offering you today has the ability to change your life. It's gonna require something from you. We're gonna need you to share that need with us, and Gabby's gonna tell you how you can do that very privately.
So I gave you these papers, when y'all came in and everything. This is only, the only person who's gonna see this. This is not shared with the court, this is not shared with anybody except for me. This is a HIPAA document, so just like your medical, documents are protected, this is gonna be protected also. This just allows me to contact you once. I'll send an initial text out. If you can't, your phone doesn't receive text, that's okay also. Just let me know and I'll give you a call. This is not gonna be a robocall, it's gonna be for me, on my work phone. And again, just allows me to contact you once. If you don't wanna respond, that's totally okay. But it just gives me a chance to reach out to you to see what needs that, we can help you get that. Two things that I really need though is I need your phone number, please, and then you have a section right here that says resources requested. You can check one of these boxes here, but we also left you a space right here, and you can fill in if there's a specific need, you can put it on here also. Just please put your name and everything in for, but most importantly, a good phone number. And if you want to talk to me today, you can check this right here now.
Also, before you leave here today, I want to give you this flyer. It tells you a little bit about the advantages of actually participating in the program. But it also has a 1-800 number on here. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, just shortly, the court is going to go into recess, and when it does, Gabby and I will be able to go out and visit and answer any questions. We'll be picking up those documents from you. I'll be handing this out to you as well. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, Deputy Hinton and Gabby. Now, ladies and gentlemen, if you need some help with filling out the paperwork, we have our court personnel who's here who will be happy to help you with filling out the paperwork. Now, we're going to come out and pick up the paperwork from you. And once the paperwork is picked up, I have to go through the paperwork. So that takes a little time to do that. Make sure that one is filled out correctly. And two, we're going to put you into one of three categories. And as follows: you could either hire an attorney, apply for a court-appointed attorney, or represent yourself. Now, if you need to use the restroom, there are two restrooms right outside the courtroom in the hall. The men's restroom is right in front of County Court at Law number 3, which is right next door. And on the opposite side of the hall is the women's restroom in front of the 172nd District Court. Now, do not leave the courthouse, because if you leave the courthouse and if we call your name and you do not answer, then your bond will be forfeited, warrant will be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. So this is not going to take us that long to go through the necessary paperwork, okay? So at this time, the court is going to go into recess. And folks from Spindletop is going to come out and visit with you. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases, cause numbers M323465 and cause number M329263. Both cases are styled the state of Texas versus Ashley Elizabeth Farrow. Mr. Farrow, you can come forward. And before we get started, Mr. Farrow is represented in her case by Attorney Thomas Burbank. Attorney Burbank, pursuant to Article 1.24 of Texas Code of Criminal Procedures, all trials and proceedings shall be public. However, pursuant to the case of Liddy versus State 365 Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing interests such as interest in security, the disclosure of non-public information, and to ensure that the defendant receives a fair trial. Mr. Burbank, in this proceeding, the court is aware that there may be some non-public information that may be disclosed. Is that correct?
That's correct, Your Honor.
So at this time, are you requesting that this portion of the hearing be closed to the public?
I am.
Okay, so ladies and gentlemen, this portion